Now call the second case on this morning's docket. Case number 115126, Ed DeWitt Insurance Agency, Inc. et al., the Financial Associates Midwest, Inc. If you give us a moment. May proceed.
May it please the court, Michael Blumenthal on behalf of the appellants Ed DeWitt, Leonard Philly, and Barbara Mitter. And I'd ask that 3 minutes be reserved for rebuttal, Your Honor.
3 minutes is granted.
Thank you, Your Honor. May it please the court. I've been asked to provide a brief overview on the facts of this case and the issue that's presented before you. Beginning in the 1980s, the appellants, Edward DeWitt, Leonard Philly, and Barbara Mitter began working for a company called Financial Associates Midwest, Inc., which I call FAMI for purposes of this appeal. FAMI was owned by one man, named Charles Stumpf, and the plaintiffs were hired to recruit and train insurance agents, to go out and sell health insurance products. And they did just that for years and years and years. And Mr. Stumpf promised them they'd be paid a percentage of the commissions and the renewals on those commissions, and that they'd be paid it not only during the term of their employment, but in lieu of a retirement plan, they would receive 1% of the renewals, particularly after Blue Cross Blue Shield started paying the company an administrative services fee, which Mr. Stumpf called an override or a commission.
Let me stop you there real quick.
Yes, sir.
Counsel, I did have a little bit of a blank maybe from when I first read all this last night, but the money to your clients is the Blue Cross Blue Shield override fee, right?
Yes.
There wasn't another 1 or 2% on anything else. It was half of what Blue Cross was paying for this administrative override.
Yes, sir.
Okay. Thank you.
Right. So the promise was made, and then Mr. Stumpf sold his business, and he sold it to Blue Cross Blue Shield, and Blue Cross Blue Shield continued to pay the 1% to the plaintiffs, including to one who had actually retired upon the sale and paid it for 9 months. And then when Blue Cross Blue Shield claims that they realized for the first time the 1%, they asked my clients to waive their right to it, and my clients refused, and they were fired. And then they sued, and they claimed that they were owed this 1%. And Blue Cross Blue Shield said, well, that's a verbal agreement. And a verbal agreement, an oral agreement in Kansas, is barred by the statute of frauds. And that presents the question then in Kansas, because there's no dispute in this case that the oral agreement was made, and there's no dispute that my clients fully performed whatever it is that they promised to do. And that begs the question whether in Kansas, applying Kansas law, we're going to adhere on to a New York exception to the statute of frauds and strip my clients of their hard-earned retirement money. And that's the question that this court has to resolve.
Were they serial oral agreements? In other words, they occur annually, or did the oral agreement occur just in the initial agreement?
I can only tell you what Charles Stumpf testified to, Judge, and you can find it in the record on volume 3, page 256, when he was asked whether or not they were going to be paid this amount even after they no longer worked for FAMI. He said, yes, that was the agreement, that if they left retired, that they would draw through the month that they left and any future business, those agents that they brought in and trained, and would go to the new person, but that business in force they would continue to get paid for. And it's our understanding, based on the evidence, that it was a singular promise to pay.
This goes back to my other question. What obligated Blue Cross Blue Shield to keep paying the administrative override after it acquired Financial Associates?
Nothing, but the record shows that they still are paying it, and they're paying it today, Judge. And there might be a lot of financial and market-based reasons why they're doing that, because they have to still keep the agents that work for FAMI incented, and it's my guess, and I can only guess, that that's why they're continuing to do it. But it's no more different than what obligates the policyholders to renew their policies. And the answer, of course, is nothing. But that actually goes to one of the key questions in this case, which is Kansas law says if there's no dispute as to the existence of an oral agreement, it takes it outside the statute of frauds. And there is no dispute in this case of the oral agreement. So the statute of frauds doesn't apply. And if I could get
I
the
get
second
that.
point,
Just let me
sure.
get clear in my head here. What your clients were promised was half of what Blue Cross pays to the company, Financial Associates. And if there's nothing that obligates Blue Cross Blue Shield to even pay anything to Financial Associates, then the promise that you're trying to enforce goes away, right?
No.
I mean, if Blue Cross quits paying the 2%, there's nothing to pay to your client.
That's a question of damages, Judge. That's not a question of liability. So in Kansas, if I can drive home this point, Kansas, we have to show the existence of an oral agreement. We've done that. Then under Kansas law, the question is whether or not the plaintiff has fully performed. The answer is yes.
Well, let's go at this a different way. When one of the plaintiffs or one of their people that they manage sold a policy, then that's when the override kicked in, right? And it continued as long as that policy was in existence.
That's correct.
And so would you say that the your client's interest in that particular policy, the proceeds from that policy was vested?
Yes.
And so if they change the rules with regard to overrides for future sales, your point would be that their interest in what had already been sold was vested and couldn't be destroyed.
That's right.
Is that kind of where you're at?
That is, but if I can drive home this point, the question as to whether or not payment is made in the future is a condition precedent to the company's obligation to pay my client. It is not a condition precedent to whether my client has fully performed, okay? Because my client did exactly what they were hired to do, so they fully performed, right? And so the question as to whether or not FAMI actually receives the 2% from Blue Cross Blue Shield, or whether the policyholders renew their policies to trigger the 2% payment, that's in the future, and it's a condition precedent to the defendant's obligations, not to my client's rights.
Let me clarify that.
Sure.
I'm assuming what they were supposed to do or hired to do was to sell insurance policies and bring that policy into existence. Was there any obligation for them to do anything or manage any people that did anything with respect to the policy once it was booked? Once it's on the books, was there anything that, any kind of maintenance or administrative duties that had to be done?
No.
Just cash the checks when the premiums are paid?
And Your Honor, I understand that you sold insurance policies at one point in time. It's no different here than probably when you sold your policies. Once you book the policy and you start getting override renewals, it's your override renewals. There's nothing more for the agent to do, or in this case for the agent managers to do, than make sure that the policy gets renewed, and if it gets renewed, then they get the check. And Blue Cross Blue Shield would administer the renewal. And so that ultimately that goes to the core issue in this case, because we have to look at it when we have, first of all, the admission of the agreement. You know, it takes outside the statute of frauds, and we've briefed that. But more importantly, this court has adhered for 130 years to the restatement second of contracts view.
Let me stop you there.
Yes.
I want to hear what you have to say about that, but I want to stop you just before you get there. In the fairly recent past, last 10, 15 years, this court has adhered pretty strictly to a specific paradigm for statutory interpretation and construction. And the statute itself in Kansas, despite the common law history that you're about to describe to us and the common law future you would like us to adopt, the statute itself says nothing about this exception that you would like to invoke.
It hasn't, Judge, but the statute hasn't changed since it was enacted. And this court has been applying the exception I'm talking about since it was enacted.
So it's your position that we should disregard our current practice on how we do statutory interpretation and construction.
I'm asking-
And continue to apply the common law as you see it.
That is stare decisis at its essence, particularly when it comes down to contractual matters, because the time my clients entered into the contract, the law in Kansas, which it is as reflected in the law today, embracing the restatement view of contracts. And the restatement view of contracts under section 130 subparagraph 2 says when one party to a contract has completed his performance, the 1-year provision of the statute of frauds does not prevent the enforcement of the promise, period. There's no but, there's no except. And that's what the Court of Appeals did wrong here, was they put an except, and they put the exception in embracing a concept anchored in New York law. And when we look at New York law, it's distinguishable entirely from those states, Kansas, Iowa, Mississippi, Florida, that embrace the restatement view of the exception I've just espoused, the single party full performance doctrine. In contrast, New York law, which was embraced by the Court of Appeals, doesn't at all embrace the Kansas or the Iowa view. Instead, it says that there has to be full performance by both parties, and full performance has to be within 1 year. That's entirely different from 130 years of Kansas jurisprudence. Then New York law on top of that says that it doesn't recognize what Kansas law has recognized for years and years. And by then embracing that New York view, we're actually taking a sea change and a pivot away from the stare decisis concepts that have been at play in this court for many, many years. I'd like to circle back to this concept of there being no dispute about the existence of the contract. Because Kansas law has recognized in Quaney versus Tobin, which can be found at 236 Kansas 201, in the concept of a UCC case, that where the other party admits the existence of the contract, that removes it from the statute of frauds. Other courts have uniformly embraced that concept. And in this case, there is no dispute. You know, the statute of frauds, to come back, Justice Breyer, to this concept of stare decisis, this court held in Augusta Bank, which recognized Section 130, the statute of frauds was enacted to prevent fraud and injustice, not to foster and to encourage it. And the courts, as far as possible, refused to allow it to be used as a shield to protect fraud and a means to enable one to take advantage of his own wrong. Could there be any sentiment more at play than in this case? Where Mr. Stumpf, to his credit, to his detriment, when he was sued by Blue Cross Blue Shield for allegedly failing to reveal his contract, testified, yeah, I made that oral agreement. All he had to say was, no, there was no agreement. And he would be off the hook from the claim against Blue Cross Blue Shield. And instead, he was a man of his word, and he admitted to it. And of course he admitted to it, because he'd been paying these people this for 2 decades. And these people relied on it. And what Blue Cross Blue Shield's now doing is attempting to use it to get off the hook, because they find it to be not a good deal for them. And that's not fair, and that's not what Kansas law embraces. And I'll reserve my time for rebuttal.
Do you have any more questions of counsel?
How long did Blue Cross continue the overrides after they discovered the existence of that contract?
9 months, Judge.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Sarah Warner on behalf of Appalese Financial Associates Midwest Incorporated and Blue Cross and Blue Shield of Kansas City. We've heard a lot today, and I want to clarify a few things. The first of those is there has been no admission or agreement that this alleged oral agreement exists. The district court found that at best there was an oral agreement between Stumpf and the managers, and that place in the record is at record 4, page 30. It's page 14 of the district court's opinion. the district court also found that there had been no full performance in this case. That's at record volume 4, page 36. That's the district court's opinion at 20.
And what was the rationale for no full performance?
Because among other things, the district court found that the managers in this instance had not performed in any manner that hadn't already been compensated, and so they were claiming this vested interest in payments, but there wasn't any performance that would render those payments due. And
So a life insurance agent that sells a life insurance policy that usually has a big upfront commission, and then it reduces and it lingers for the life of a whole life policy, then those aren't really vested interests. If it's 20 years from now, they're getting 1% of the policy pursuant to the commission agreement with the company can just stop paying that and say, well, they're really not doing anything more. They sold it for us in the first place like they were supposed to, but now they're not doing anything, and so we don't have to perform what we said we'd do.
So I think that there are two responses there, Your Honor. The first is, as you mentioned, that there is usually a commissions agreement. And in fact, in this case, there was a written contract that governed commissions. And that written contract included a vesting provision for those commissions. What the district court found, and the Court of Appeals has affirmed, is that written contract didn't cover the compensation that we're talking about here. So the compensation that we're talking about in this case is not a commission. It's not based on an action by these individuals going out and selling or procuring policies. Instead,
How can you say that?
that is an admission. That is an uncontroverted fact that was before the court at summary judgment.
This was a separate deal from the written contract for commissions.
That's correct.
Okay.
That's correct.
I'm still waiting for the rest of the explanation because I have a question maybe to follow up.
So there, in some instances, there's a written contract, and there was a written contract covering those commissions in this case. And then the other side of it is that these were not commissions. Those, again, that's something that has been found by the district court,
Was it
found
just
by
a
the Court of
gift?
Appeals. What's
I mean,
that?
what was it then? Just a gift?
No, it was compensation for employment. So the district court specifically found that these were employment actions. So this is different from independent insurance agents who are going out and selling policies. These were employees of financial associates, and what they were doing is they were
You're saying
supervising.
I'm sorry to interrupt, but it sounds like you're saying under your construction of the contractual language, what has occurred here isn't actually a violation of the agreement because they're no longer employed.
I think that that's true. I mean, to the extent that this court would allow the full performance exception to allow employees to make a claim after the fact that performance they had already received compensation for, that same performance could be used through the full performance exception to allow them to make a claim for additional performance would open the door.
Compensation. You're seeing it as additional compensation.
Additional compensation.
Because they're seeing
right.
it as finishing the compensation they were due for the performance they already finished. Yeah, I mean, you just have opposing.
I think that's true. And I think that that's the reason why we have the statute of frauds, why the Kansas legislature has made this policy assessment that in these particular instances where you have a policy or a contract that can't be performed in a year, then there is a benefit to requiring some kind of reliable evidence.
Well, if it weren't for the statute of frauds, let's just say, I mean, isn't what would happen is that the parties would go back and litigate the terms of the agreement, and you and your clients would argue, no, the contract doesn't require us to pay for whatever reason.
Right. Oh,
And they would say, well, yes, it does, and then you would litigate that.
I think that's true. I mean, the first point would be that there was no contract to begin with. That's the first point that would be litigated. And then if there was a determination that there in fact was this agreement, then what were the terms of that agreement? And this is again, this goes to the point of the statute of frauds. All of the evidence that would come in there would be the exact kind of evidence that the statute of fraud endeavors to exclude. So the only evidence of this agreement, this alleged agreement, is oral testimony. There's nothing, so in most instances when you're talking about the full performance exception, and in fact, in all instances where that has come up in Kansas, the performance itself is extrinsic evidence that this agreement exists. So there's something outside of that oral testimony that demonstrates the existence of an agreement.
But the statute doesn't preclude oral testimony about a contract for me contracting to pay you to do something for me. It only precludes that if the agreement is not to be performed within the space of 1 year from the making thereof. Correct?
That's correct.
And the argument here is the agreement was you go out and sell us policies for us, and we're going to give you additional compensation as part of the override is the additional compensation, and we're going to pay that to you for the rest of the life of the policy. Now, wasn't that the agreement?
I think
At least that's the agreement that was testified to by Mr. Stump.
I actually, just to clarify, that wasn't the agreement. So the agreement was, as long as you are acting as a manager here, then you're going to be paid half of this administrative services fee that's paid to the agency. And that administrative services
But
fee happened to be
for
calculated.
all policies, or just the policies that were sold by that person, the area managers, or the people they are supervising?
So the way that fee was calculated, it was based on all of the people who they were supervising and managing.
So it's not all overrides coming to Financial Association Midwest. It was those overrides coming to Financial that were attributable to the area manager's area.
I think that's true. So it would take, the administrative services fee, 50% of that would be divided up according to however those premiums, those renewal premiums are paid under those.
And that was to be paid,
different
excuse me, let me
managers.
finish
Yeah,
out
go
with
ahead.
that, because I don't think I got the total answer on what. So that was to be paid for the life of the policy.
I think that is the allegation, yes. As long as
and
that.
it wasn't to be paid for a succeeding area manager that has that area. It was to be paid to that area manager that was in place when the policy was originally sold. Is that right?
So it's unclear because there hasn't been a whole lot of testing about what that actual agreement was. This has been kind of a moving target.
Okay, let's say that is the
Okay.
case. That is the fact. And so that the area manager, what other performance needed to be done after the policy was booked under the agreement as I've described it? You go out, you get these people to sell insurance, and we'll give you half of the override for the life of the policy, even after you retire. And what else was there for the area managers to do to perform under that agreement?
I think that the area managers would continue to provide those services, right? So the disconnect is that they are
on the state policy sold to me.
right. Although, but so the area managers, the plaintiffs, appellants in this case, had no contact with the policyholders themselves. They never sold the policies. They would never go to you and say, "I'm going to sell you a policy." They did no work to renew those policies. They just had the administrative aspect of running the office, and then to the extent new agents came in, training those agents, answering questions, those kinds of activities, but
They've
not
done
selling.
everything. But they've done everything they were expected to do. Is that right?
To the extent any employee during the stint of your employment continues to do the job that you're supposed to do, yes. But the problem, and I think that the reason that the full performance exception just doesn't apply here, and I direct the court to that line of cases that we cited in our response supplemental brief from Texas, is that if you, the point of the full performance exception is that performance, that alleged performance, provides some extrinsic evidence of the agreement, other than just the oral testimony that the whole point of the statute of frauds is to exclude.
Okay, I understand the statute of, I understand how you're using the statute of frauds as a shield, but I want to get back to the facts. And I'm looking at page 10 of the district court order, which is under the major heading of uncontroverted facts, and it says that Stumpf even verbally agreed that plaintiffs would continue to receive the override after their employment with FAMI ended, until the policies they had signed were no longer renewed. So, if I take that as an uncontroverted fact, by definition, the plaintiffs would have done all they were supposed to do to earn that compensation when they landed, or when the insurance policy was landed by the company. So I don't see how we're talking about there's still more performance that the plaintiffs are supposed to do as being required by this agreement. Now, again, I understand that you can say, that isn't good enough because I got this statute of frauds in my pocket. But just in terms of what was agreed to between the parties, the plaintiffs didn't have to do anything more as those policies renewed, right?
So, two responses.
So what am I missing in all? I mean, I'm looking at this. What am I missing?
The first is I just want, for purposes of the record, the district court made that finding, and if you look in the briefing, the briefing by the appellees, by financial associates on that point was, we don't think that this is credible, but even if it were credible, it would be barred by the statute of frauds. So I just want to clarify that little point just for purposes
But that would have been sort of
procedurally.
through a motion to dismiss. You know, the district court would have said, okay, I'm going to take the fact as alleged by the plaintiff, but you got a statute of frauds here and you're dead. But this is done as a summary judgment motion where the fact is established, as near as I can tell. There's been no dispute about the district court's finding of that fact, as near as I can see in the record. So it gets me back to the plaintiffs did everything they were supposed to do in the first year that that policy landed in the company. They didn't have to do anything more because they could retire and still get the money.
That is the allegation. But if that is the kind of thing that we can use the full performance exception to take you outside of the statute of frauds. If all you have to do is say, I was entitled to additional. I wasn't just entitled to the compensation I received for this performance, but this performance was also, I was supposed to get paid more on top of that.
Well, if that's all you have to do is say that, plus find somebody else to say it, so that a district court says it's an uncontroverted fact.
And you know, to that extent, the alignment of the parties is kind of interesting here. So now, at least one of the area managers continues to work for Stumpf. Stumpf is in litigation against Blue Cross and Blue Shield because he didn't disclose this alleged oral agreement until after the fact, right? Until after. In fact, he had been continuing to run the company after Blue Cross acquired it, and when Blue Cross found out about it, then the administrative services fee stops, the payments stopped, there's a
I want to
discussion.
talk about that, but I want you to go ahead and fully answer. But I want to visit about that other, if you're bringing up the other lawsuit here, I want to talk about it, but you go ahead and fully answer
So-
Justice Miles.
So I think that my answer would be under the allegations here, they are saying that we've done everything that we need to do to attain these payments, and I would say that if you look at the way that Kansas has defined and used the full performance exception, number one, it's been a fairly narrow exception that is only applied when there have been personal services contracts that require nothing else to be done but payment. And number two, there have not been instances where Kansas has allowed the full performance exception to be a vehicle for additional payments. So, and in fact, there's one specific case.
I don't get the characterization of this as additional payment if this fact is true. If we're going to assume this fact is true, then their payment, then their agreement, their payment for what they did in year one is just getting spread out over however long this customer keeps renewing.
So, and I think that the key is that I would agree with you that is certainly the way they have portrayed this alleged agreement, right?
Right, and your point is it doesn't matter,
But even beyond that, I would say that the reason why this doesn't fall within the full performance exception is that courts haven't used the full performance exception. And in fact, courts across the country have been very reticent to use that exception when there has already been some consideration, some payment made for the performance that is being claimed. So the only evidence of that would give rise to the full performance exception, as you're describing it, that these people performed all of their work during the course of when those policies were initially undertaken. The only way that would come into play is if there were testimony about the nature of that, and the purpose of the statute of frauds is to eliminate that testimony, that testimony is inherently unreliable.
Justice
Further
Johnson,
questions?
did you have a question?
You mentioned that Blue Cross Blue Shield is suing Mr. Stump for failure to disclose this agreement. But if there wasn't an agreement, how do you have a basis to sue? And it seems to me that's an acknowledgement that when they bought financial, they also bought this agreement. I mean, it's kind of talking out of both sides of your mouth. There's nothing there, there's no agreement, but we're going to sue Mr. Stump for selling us a business that had this underlying agreement as part of the purchase price. So explain that contradiction to me.
I think that lawsuit has been filed and is stayed to see what happens in this case. And I think that...
But the point is, the allegation in that lawsuit is that we bought Financial Association Midwest, Inc. and all of its contracts and its assets, and we were unaware that one of its liabilities were these agreements. And if there is no agreement, then how can you make that allegation?
So I can't speak because I'm not actually counsel in that case, but what I will say is this.
But you were the one that brought it up to use to make your argument here. That's why I'm asking you that.
What I will say is this, is that that's not the only element of damage. It's one of the elements of damage depending on the outcome of this case. It's not the only element of damage. Another is just the attorney fees in litigating this case. If
I presume it's in part at least to protect your client from collusion, essentially. I mean, and isn't that also part of why we have the statute of frauds?
Absolutely. It's again, just making sure that there is not, again, these people who are now working together again, despite the fact, I don't know how you could go to work for someone if indeed the kind of things were going on that are being alleged here. But certainly I think, it's a protection there. It's also, just to file the lawsuit, I think that there was a need to file for statute of limitations purposes to make sure that all of
sure you
those
didn't lose your
defenses
claim.
were sustained.
Conditional claim, basically.
Absolutely.
Do you want to crack at how we do statutory interpretation and construction?
I would love that. So in Kansas, and of course in recent years, we have been very clear that the first step is the text of the statute, because that is the only clear evidence of legislative intent. And so here, the statute 33-106 specifically says that these kind of agreements, so an alleged agreement that would take longer than 1 year is not enforceable unless it is in writing. And so that's in writing and signed by the parties, right? So that is a very clear indication from the legislature regarding the enforceability of this agreement. The legislature has weighed in on this subject. And it's true that this court, or in the past, and Kansas courts in the past have applied this equitable exception, the full performance exception. But to the extent the court has never applied the exception to in the way that is being advocated here, in particular, to require what I would say is additional compensation for performance that has already been compensated. That's a broadening of the exception. And this court has been very clear that we're not going to do that. Instead, we are going to read judicially created exceptions to statutes narrowly. And I think that that's particularly important here, where the legislature has engaged in the policy considerations and the policy weighing that this court is engaging in right now. So in these particular instances, the legislature has determined that the reliability of evidence and the certainty of agreements outweigh general considerations regarding whether a contract should be enforced, regardless of how it was made.
So you're making a counter parade of horribles argument. Yeah, I mean, it sounded to me like your opponent was saying, if you undo all this law, I mean, it's really what we have stare decisis for, regardless of your methods for doing statutory interpretation and construction now. We've been doing it this way for 130 years, and upsetting that apple cart now would have very negative effects on insurance policies, how they're written, how people are compensated for getting them signed, etc. And you're saying, well, we don't have to go nearly that far, because this is an extension of the common law exception that they're arguing for. Is that a fair statement of your position?
Yes,
Okay.
yes.
I understand. Thank you.
Any more questions? We've taken a lot of your time with our questions. Would you need 30 seconds to wrap up, or do you think you've made your position known?
Thank you, Your Honor. I'd like to take just a few seconds to wrap up. So I want to make it very clear that appellees are not arguing that agreements like this regarding vested payments can never be enforceable. It's just that under KSA 33-106, in order to be enforceable, they have to be in writing. The lower courts correctly determined that the enforcement of the alleged oral agreement here, which is based precisely on the kind of evidence that the statute of frauds was enacted to exclude, is barred by the Kansas statute of frauds, and I would ask this court to affirm.
Thank you, counsel.
Thank you.
You've reserved 3 minutes for rebuttal.
May it please the court, let me begin by answering unequivocally and squarely the question that respectfully my defense counsel danced around. And the question from the court was, what did the area managers have to do to fully perform under the contract? And here's the answer: nothing. they fully performed. Right? We are not asking for an extension of Kansas law. We're asking for the application of Kansas law.
On that point, counsel, if you indulge me in a hypothetical question.
Sure.
You hire me to paint your fence. You say, I'll pay you $1. Or that I paint your fence, you pay me $1. The next year I file a lawsuit against you saying, no, he promised to pay me $1 every month for the rest of my life. On your position, this is a lawsuit you have to defend on the merits, right? It's not in writing. It's just your word versus my word.
Okay. First of all, that's not the facts here, because it's not your word against my word. It's my word.
Well, that's the
and their word.
hypothetical. I want
Okay.
you to assume that there's
I can
a factual
actually
dispute.
answer your question, Judge, and I can cite to you a case that answers the question. It's Brown versus Byers, 118 Kansas 503 from 1925, where some farmhands were hired to do the equivalent of painting the fence. And in your example is if the plaintiffs fully performed in painting the fence and were told they would get a renewal for painting the fence for year in, year out, and they fully performed, the answer is that would take it outside the statute of frauds.
Right, that's your position. And I guess that my just follow-up question is,
Sure.
I mean, I reduced the problem to what, in my mind, its simplest form. And it just seems like, isn't that exactly the kind of contract that the statute of frauds is intended to require to be in writing?
No, I mean, that's not what 130 years worth of Kansas law says. It just isn't.
It's a type of contract that's intended to be included if it's more than 1 year to perform. But the
Right.
short terms, not.
And-
But that type of contract, if it's, I need you to paint it every month for 18 months, then performance hadn't happened within 1 year, and you would be subject, right?
I think the answer is yes. And to take this, I know hypotheticals are dangerous ground, of course, but let's assume that you asked me to paint the fence and you pay me $1 this year and 10 cents every following year, assuming that somebody came by and opened the fence door. I'm just making this stuff up, obviously, right? Right. My performance is fully performed, and that it's conditioned on somebody else doing something in the future that might trigger payment, might have to do with whether or not I'm owed the money, but not in terms of what amount of money I'm owed, but it doesn't have anything to do with whether, in fact, you owe me money, if that makes clear. That's the problem with these hypotheticals, of course. We can just take them on and off. But ultimately, we're not asking for an extension of Kansas law. We're asking this court to apply Kansas law. They're asking for the extension of Kansas law. And I'm out of time, but I asked to be able to wrap up briefly, and I won't take long.
I'll give you 30 seconds, counsel.
Thank you, Judge. In the case I just cited, the court talked about how where one party to an oral accord in an oral contract has no reliance thereon, so far performed as part of the agreement that perpetuating a fraud upon it would allow the other court to repeat the contract. Equity will regard this case as being removed from the operation of the statute of frauds. That's what's going on in this case. They are using the statute of frauds not on a motion to dismiss, but on a motion for summary judgment, where it's been adjudicated that this oral agreement exists. The trial court found that it exists. The Court of Appeals found that it exists. And Mr. Stumpf, to his detriment, says that it exists. And I asked this court to on behalf of 3 very nice, hardworking people who spent decades laboring on behalf of family in reliance that they would have this amount paid for them when they retired, to apply Kansas law and not to allow the defendants to use it as a shield to escape the obligations of a contract that now today they just don't like. Thank you, Your Honor.
Do we have any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.